Dissent is the safety valve of democracy. Those are the words of Justice D.Y. Chandrachud, delivered not in a courtroom but in a public memorial lecture, at a moment when university campuses all across India were boiling over. He added something sharper right after it, that when a government brands every act of dissent as anti-national, it strikes at the constitutional values the country claims to protect. Now, I want you to hold on to that phrase for the next 20 minutes, because today we are not just discussing an abstract constitutional right, we are watching it play out live on the streets of Delhi. As I record this, Parliament Street and Connaught Place are still carrying the scars of a clash between thousands of students and the Delhi police. Broken barricades, blood on the pavements, tear gas that has not fully cleared. Delhi police itself has confirmed that close to 180 people were injured in a single day of confrontation. Now, the real number, of course, would be much more beyond that. Now, around 5 FIRs have been also registered, and the protest is not stopping. And if anything, students are camping out at a Jantar Mantar tonight, refusing to leave. So here is the question I want you to carry through this lecture. At what exact point does a citizen's constitutional right to assemble turns into a police case of unlawful assembly? Where is the line drawn? And who drew that line? And does the Indian state today, in 2026, actually follows its own rules when it decides to cross the line? By the end of this video, you will be able to answer that with the actual constitutional articles, the actual statutory sections, and the actual Supreme Court judgments in hand. Not just opinions, but we will be talking about law. Now let's start from absolute basics. Let's start from the definition itself, because most people use this word democracy without ever defining it. Now, a democracy, in its simplest constitutional sense, is a system where a sovereign power originates from the people, is exercised through their consent, and critically remains accountable to the people between elections, not just during the elections. Now, that accountability between elections is the part everyone forgets. Elections happens once every 5 years. Accountability, if it means anything, of course, has to be a daily mechanism. Protest is that daily mechanism. It is the feedback loop that a democracy theory depends on. The way citizen can signal to the state in real time that a policy, a leader, or a decision has lost legitimacy in their eyes, without having to wait for the next ballot. This is not just a modern liberal argument. It is embedded in how India itself was born. The most defining mass movements of the Indian freedom struggle, the non-cooperation movement of 1920, the Dandi Salt March of 1930, the Quit India movement of 1942, were in the strictest legal sense of the term illegal assemblies under colonial law. Now, they were protests against a state that refused to recognize their right to dissent. When the Constituent Assembly sat down years later to write independent India's constitution, they were not writing it in a vacuum. Many of the same men who had been arrested for organizing those illegal protests were now the ones drafting the fundamental rights of the new republic. That is why the right to assemble was not treated as a footnote. It was written directly into Part 3, the Fundamental Rights chapter, sitting right next to the right to free speech itself. Now, here is the exact text you should know, and all of you should know about this. Article 19(1)(b) of the Constitution of India guarantees every citizen the right to assemble peacefully and without arms. Now, this right was never drafted as absolute. It carries its own internal limits from the moment it was written. And then comes Article 19, Section 3, which allows the state to impose what the Constitutional calls as reasonable restrictions on this right. And in the interest of the sovereignty and the integrity of India, or in the interest of public order, two things matter enormously here. First, the word reasonable it's not decorative. Courts have repeatedly held that the test of reasonableness must be applied individually to each of the restriction, not as some vague one-size-fits-all standard. And the second thing is that the restriction can only be justified under the specific grounds Article 19 lists, nothing outside of it. In fact, the Honorable Supreme Court of India, in an unanimous 5-judge ruling, held explicitly that the state cannot invoke some other unrelated constitutional provision to smuggle in extra restrictions that Article 19.2 or Article 19.3 never authorized in the first place. So the constitutional architecture is actually elegant once you see it. A citizen has the real right to assemble. The state has the real power to restrict it, but the power is boxed in on every side. It must be reasonable, it must fall within the listed grounds, and the courts retain the final word on whether it qualifies or not. Now, the first time the Honorable Supreme Court of India had to seriously test this balance was in Himmat Lal K. Shah versus the Police Commissioner of Bombay, decided in the year 1973. Now, a police rule in Bombay had effectively empowered the commissioner to impose a total ban on the all public meetings and processions in certain areas at his own discretion, with no published guidelines on when or why. The Supreme Court of India struck this down. Its reasoning was very precise. The state can regulate the right to assemble, manage traffic, control timing, choose locations, but it cannot prohibit it altogether through unguided administrative discretion. A rule that hands one official the power to simply say no to every meeting with no criteria to be reviewed against is itself unconstitutional. Now, this single judgment set the tone for every case that followed for the next 5 decades. Regulation, yes. Blanket prohibition, no. Now let's get to the provision that actually shows up in the news headlines every single week, or used to be shown. It was section 144 of the old Code of Criminal Procedure. As of July 1st, 2024, India's criminal procedure law itself has changed. The CRPC was replaced by Bharatiya Nagrik Suraksha Sanhita, and the older section 144 is the now section 163 BNSS. Now the substance is nearly identical, only the number has changed. So when your grandfather says Dhara 144 laga di, he now technically means section 163. Now here is what it actually allows. A district magistrate or a sub-divisional magistrate, specifically empowered by the state, can issue a written order in urgent cases whether there is a real, immediate risk, obstruction, danger to life, disturbance of public tranquility, or the apprehension of a riot. This order can prohibit an assembly of 5 or more people, or the carrying of weapons in a defined area. Now, crucially, the law places a time cap on this power. The order ordinarily lasts up to 2 months, extendable by the state government to a maximum of 6 months. It cannot simply run forever. And this is where the courts have stepped in again recently. A Gujarat High Court ruling on the rolling prohibitory orders explicitly condemned the practice of magistrates issuing back-to-back section 163 orders to effectively bypass the 2-month gap, and what this court called as rolling orders. Now the judgment held that such orders, when they have the effect of shutting down all protest activity indefinitely, are constitutionally suspect, and that preventive power under the section can never be used to suppress the legitimate expression of a grievance or the exercise of a democratic right. Now the court also mandated that these orders be publicized widely, not buried in a government gazette, nobody which of course reads, but pushed out through newspapers, through televisions, through social media, in the language people actually speak. Now sitting right alongside section 163 is the definition every police FIR in a protest case relies on. That is unlawful assembly. Now codified under section 189 of the Bharatiya Nyaya Sanhita, replacing the old IPC section of 141, an unlawful assembly in a law is any gathering of 5 or more people who share a common unlawful object: to overhaul the government through criminal force, to resist a lawful legal process, or to commit an offense. Now this is a non-bailable, cognizable offense, meaning police can arrest without a warrant the moment that threshold is met. Punishment ranges up to 6 months for ordinary members and up to 2 years for those found carrying a weapon. Now this is the exact legal hinge on which the difference between the protest and case registered turns the moment a peaceful assembly's common object shifts towards force or obstruction. It stops being protected speech and starts being a chargeable offense. Now here's a case study most people have actually heard of but never actually read. In June of 2011, all of you know Baba Ramdev was holding what was officially a residential yoga camp at Delhi's Ramlila Maidan, which quietly turned into an indefinite hunger strike against corruption, with the tens of thousands of supporters gathering. Now, in the middle of the night, Delhi police moved in and forcibly evicted the sleeping crowd, including women and children, using force that the Supreme Court itself, acting on its own initiative after media reports, later found to be excessive and unconstitutional. Now, the 2012 judgment is genuinely fascinating because it refuses to give either side a clean win. The court held that the police action violated the fundamental rights of the assembled citizens under Article 19 and 21, and it ordered compensation, 5 lakh rupees to the family of a woman named Raj Bala who died in the crackdown, 50,000 rupees for those grievously injured, and 25,000 for minor injuries, split between the government and Ramdev's organization in a 3-to-1 ratio. But in the same breath, the court also held Ramdev partially responsible for failing to cooperate with a lawful police direction to evacuate once Section 144 had been properly invoked. Now, the lesson this case teaches is one of the mutual obligation. The state cannot use midnight force against a peaceful sleeping crowd, but organizers of a protest also cannot simply ignore a lawful order and expect zero consequences when things turns violent. Now let's fast forward to the year 2018. Residents near Jantar Mantar, which is for decades Delhi's designated protest ground, had complained for years about noise and disruption from constant demonstrations. In Mazdoor Kisan Shakti Sangathan versus Union of India, the Supreme Court had to balance two competing rights: the protesters' Article 19 right to assemble against the residents' right to a peaceful living environment. Rather than banning protests at Jantar Mantar altogether, the court directed the authorities to draft clear written guidelines on timing, decibel limits and permitted numbers so that the protest could continue without becoming an open-ended nuisance to a third party who never chose to be a part of the demonstration. Now, this judgment matters today for one direct reason. The students currently camped at Jantar Mantar are protesting inside a space whose very ground rules were shaped by this 2018 case, which is why you must know about this case very well. And the next case is probably the single most cited protest judgment of the last decade, and it speaks directly to what is unfolding in Delhi right now. Let's fast forward to now the year December 2019. Women in Shaheen Bagh began an indefinite sit-in against the Citizenship Amendment Act (CAA), blocking a key stretch of the Delhi-Noida link road. Now, the protest ran for over 100 days. A petitioner, Advocate Amit Sahni, approached the Supreme Court arguing that while the right to protest is real, an indefinite blockade of a public road that other citizens depends on for daily commute cannot be treated as unconditional. And in October 2020, a 3-judge bench led by Justice Sanjay Kishan Kaul delivered its answer, and it is worth repeating precisely because it will get quoted at you constantly in current affairs coverage. Democracy and dissent go hand in hand, but the demonstration of that dissent cannot occupy public ways and public spaces indefinitely. Now, the court's logic was that no fundamental right exists in isolation. Every right has to be balanced against the other equally real rights of other citizens. Now, the review petition against this judgment was dismissed in February 2021, making this the settled legal position today. Now, you have an undeniable right to protest today, but not an undeniable right to occupy a specific public road forever. Apply that test directly to what is happening today. The Delhi student movement's initial march towards parliament and its current sit-in at Jantar Mantar sit on opposite sides of that legal line. A march that disperses is one thing. An indefinite occupation of a public thoroughfare is a different legal question entirely. And it is precisely this distinction that will determine how courts respond if this protest is challenged the way Shaheen Bagh protest was challenged in the courts of the country. Now, here is one more dimension of the protest law that almost never makes it to the classroom discussion. What happens to the internet when protest escalates? In January 2020, the Supreme Court decided Anuradha Bhasin versus Union of India, arising from the prolonged internet shutdown imposed in Jammu and Kashmir after the abrogation of Article 370. The court held that the freedom of speech and freedom to carry on trade or profession over the internet enjoys constitutional protection under Article 19(1)A and 19(1)G, meaning an internet shutdown is itself a restriction on a fundamental right and must clear the same constitutional hurdle any other restriction does. It laid out a 4-part proportionality test. First, the restriction must serve as a legitimate aim, have a rational connection to that aim, be the least restrictive option available, and be proportionate overall. Now, it further held that shutdown orders must be published, reviewed by a dedicated committee every 7 working days, and can never be indefinite. Now, here is where the statistics becomes genuinely alarming. According to Access Now and the global Keep It On coalition, India recorded 116 internet shutdowns in 2023 alone, the highest number of any country on earth for the 6th consecutive year in a row. In 2024, that number fell to 84, which actually made India slip to 2nd place globally, behind Myanmar's military junta at 85. Now, this was the first time in 6 years India was not the world's single worst offender. Of those 84 shutdowns in 2024, 41, nearly half, were directly linked to the protests, and rest largely to communal violence. Now, states like Manipur, Haryana, and Jammu and Kashmir accounted for the bulk of them. And 4 years after Anuradha Bhasin laid down binding guidelines requiring publication and periodic review of every shutdown order, courts have had to keep stepping back in, as recently as last year, to force compliance with the ruling the executive still frequently ignores in practice. Now, let's put every piece we have covered onto actual events unfolding this week. The protest began as a satirical online movement, self-branded the Cockroach Janata Party, that grew into a genuine student-led challenge over a recurring examination paper leaks in our country, following a wave of student suicides linked to the crisis. Now, activist and scientist Sonam Wangchuk's hunger strike and a subsequent forcible removal to a hospital escalated public anger very sharply. And when thousands marched from Jantar Mantar towards Parliament during the monsoon session, Delhi police used tear gas and lathi charges to stop them from reaching the parliamentary perimeter, an area where assembly is far more tightly restricted than any open designated ground like Jantar Mantar itself. Now, every legal question we discuss today is live in this single event. Was the force used by the police proportionate in the way Ramlila Maidan demands, or excessive? Was any prohibitory order under section 163 BNSS properly reasoned and time-bound, or could it become one of those rolling orders the Gujarat High Court had already condemned? Does the ongoing sit-in at Jantar Mantar remain within the designated space guidelines from the 2018 Mazdoor Kisan Shakti Sangathan judgment? Or does it risk drifting towards the indefinite occupation problem that sank the Shaheen Bagh protest legally in 2020? These are not rhetorical questions. These are the exact tests a court would apply if this matter reaches the court. So let's close with the harder questions, because I feel that a lecture that doesn't leave you slightly uncomfortable hasn't done its job. See, if Article 19 protects assembly, but Section 163 BNSS lets a magistrate suspend it within hours, who actually holds more power in practice? Is it the citizen, or is it the executive? If a protest starts peacefully, but a small fraction of the crowd turns violent, should the entire assembly lose its constitutional protection under the unlawful assembly provision, or only the individuals who acted? If the Supreme Court has already ruled that public roads cannot be blocked indefinitely, does that same logic eventually applies to Jantar Mantar itself? Or does a designated protest ground gets treated differently precisely because it was designated for that purpose? And finally, the last question. When the state records 84 internet shutdowns in a single year, and nearly half of them are tied to protests itself, is that tool being used to preserve public order, or a tool being used to make dissent logistically impossible without ever technically banning it? Now, I'm not going to answer these questions for you. That's not what this channel is for. What I want you is to walk away with this. The right to protest in India is neither absolute nor imaginary. It sits inside a very specific, very testable legal architecture built case by case over more than 50 years. And every single confrontation you see on your screen this week is being measured against exactly that architecture. Whether the people on either side of the barricade realize it or not, it is the test of democracy and the rights of individuals and the powers of citizen and executive. Now think about where you would draw the line. I'll see you in the next one. I hope you gained a new perspective from this session. All the very best. Have a beautiful day. Thank you.